Good morning, everyone. My name is Nancy Grimm, as you all know, and I'm so happy that you were able to attend today our presentation on domestic violence and final protective orders. We have Thomas Mulinazzi and Sarah Nadolny here who will be presenting this wonderful seminar. I hope you all are staying warm. I hope you all had a wonderful holiday. And without further ado, I'm going to turn it over because this is a full seminar, likely to take every bit of the 3 hours. So let's get started. Thomas and Sarah, go ahead.
Sarah, it's okay. I'll start because Sarah's the talent, and I'm just the one who's hopefully going to have some interesting anecdotes.
You're just a sideshow.
Basically,
right?
So
I just rolled my eyes real hard, but that's okay.
First of all, we know that many of you have a lot of experience, so there are going to be times when we're talking under you, and unless Nancy tells me otherwise, we're going to do that for posterity, because I think MBLS is going to, well, they are recording this, and they'll show it to folks who are either just starting out or don't have anywhere near the experience you have. So I will apologize for that in advance. Nancy can cue us to, I can't see anyone else's face, so I'm at a distance.
Yeah, neither can I. Yeah, that's the unfortunate part of these programs. We can't see your faces, but we know you're there.
I'm an expert in self-delusion. I'll just pretend everyone's super excited. But if you want to send me a chat that says, hey, whatever you want. Just want to let you know in advance that's what we're doing. So we, like many of you, have a lot of experience in this, but I'm going to embarrass Sarah. I don't think anyone has as much experience in this as Sarah. Through life circumstances, she did the full 10 plus years of public service law, public interest law, and worked in, I think you started off with, I think it was the Domestic Violence Center of Howard County, then it became Hope Works. You were there with Sylvie for a long, long time. And then you went to Hartley House for a long time, becoming their interim director after Blaine's unfortunate passing. But before she came to work with us, and she was one of the few who were able to get that loan forgiveness thing. So look at that. So she went the full 10, 11 years. I don't know anyone else who's stuck around for that long. Maybe Lisa Jordan over at Sally. In any event, Sarah's the expert, subject matter expert, and we all have interesting anecdotes and things to share. So I've already introduced myself at the last go round, so I will shut up. And Sarah, in a matter of moments, it's your turn to talk. So,
and may I interrupt one moment? If you would all mute your microphones, there is some background noise coming through. I'm hearing it. I would appreciate it. Thank you so much. All right, Sarah, you ready?
Yep. Hi, everyone. I'm Sarah. Thomas almost had it right. I started at Hartley, went to Hope Works, and went back to Hartley. But I also have my Master's of Law, specifically in domestic violence and marital rape. All right, so what is domestic violence? A lot of people think they know what domestic violence is, but what they actually know is domestic abuse, and that's the all-encompassing umbrella term for when people are experiencing negative things in their relationship that then has a traumatic effect on them. So domestic abuse, it's on your screen. It's a pattern of coercive control. Evan Stark wrote a book. I think it's not, nope, that's not the right one. Stark wrote a book though, called Coercive Control, that can give you lots of examples if you're interested in that. But domestic violence is not domestic abuse. So what people often come to attorneys for, saying I've been abused, isn't necessarily abuse under the law. So if you want to go to the next slide. So domestic abuse, again, is everything that could be used to control a person, even if it's not recognized under Maryland laws as a form of domestic violence. So domestic violence is defined under Family Law 4501. So domestic abuse is going to be physical abuse, sexual abuse, psychological abuse, financial abuse, isolation, whether that be geographically or slowly isolating someone from their support network, emotional abuse, verbal abuse, stalking, harassment, showing up at your work, all of those things. Domestic violence, on the other hand, like I said, is specifically defined by a statute. That's going to be physical abuse that amounts to an assault, a threat of imminent serious bodily harm, sexual abuse, false imprisonment, and they recently, within the last 5 years or so, added revenge porn. So if you want to go to the next slide. I'm not going to go through all these. You guys can read, I'm sure, but if you're hurting someone, it's going to most likely fall under physical abuse. If you're threatening to hurt someone, it's going to be physical abuse. You can go to the next slide. Sexual abuse is much broader than most people think it is. It is all the obvious ones that you would think: rape, touching inappropriately, but it's also watching someone without their permission, forcing somebody to engage in an act that they don't want to with a third person, and then there's a lot of reproductive control that can be included under sexual abuse. But that is not sexual abuse for purposes of a protective order. So it's not sexual abuse under the statute. You can go to the next slide. Verbal, emotional, psychological, and financial abuse. When I was working for nonprofits, these are the things that, I don't know, at least 30% of clients would come to me complaining about and wanting a protective order for. In most cases, this is not going to reach the grounds necessary to obtain a protective order, but it may, because again, it's going to all go back to that coercive control. What is the purpose behind the action of the perpetrator? Not every mean thing that happens in a relationship is domestic violence, and it's not domestic abuse. And I might sound like a jerk saying that, but it's not. People are still people. People still react emotionally. If it's not done with the intent to control someone in some manner, whether that be control how they're acting, having their control over their own person, then it's not necessarily domestic violence. For example, if I were to call my partner an asshole one time, that's not abuse. That's me having maybe some anger management issues. But it's not abuse. Now, if I do it every day in front of everyone with the intent of belittling him and making him question himself and lose all sorts of confidence, then that is different. A lot of people think that threatening to take your children is a threat. It is a threat, but it's not a threat for protective order purposes. So if you want to go to the next slide.
Before we do that, since I think the purpose of this is also, the intersection of domestic violence with family law, a lot of those behaviors may qualify, may one be relevant and two be not determinative, but at least evidentiary and probative of what you're trying to prove in your custody or divorce case. So Sarah and I were just involved with a case last week where a year ago, before we entered, and I don't know if there's abuse or not, our client's FPO didn't succeed, but we chose to bring up all the behaviors before and after the FPO as relevant to the custody factors, relevant to circumstances that gave rise to the end of the marriage. And even though we're a no-fault state, irreconcilable differences has to have a basis anyway. So things that are not abuse are still inappropriate, asinine, controlling, manipulative, etc., and could be relevant and probative.
Yeah, and I promise we will go in more depth after I get through these introductory slides. And actually, before we move on from what is abuse, what is not abuse, there are two major cases you should know about. The first is Castanellenbogen versus Castanellenbogen. That's 365 Maryland 122. And that is where the court said that whoever is deciding the case should look at the situation in light of the circumstances as would be perceived by the petitioner and in their position, including all of their past knowledge and experience. So that attaches to Coburn, which actually came out a few years before, which said that all prior abuse is admissible and relevant in determining whether protection is needed and what protection or what remedy is needed. And so Coburn v. Coburn and Castanellenbogen v. Castanellenbogen are the two big DV cases.
So it's subjective, not objective.
It's an individualized objective standard. According
Okay.
to the court,
Okay.
that is the quote from the court.
Maybe when you're explaining it to your clients, though.
What?
Maybe it's subjective instead of individualized.
Yes,
Objective.
just
Or not.
pretty much is the person who's experiencing it reasonable based off of all of their experiences. And if you're not reasonable based off of all of their experiences and everything, then you're not likely to get the protective order. Yes.
Sarah, do you have a list of the case law that you're going to be, or is it within that you're going to be speaking about, or is it in somewhere here in this presentation?
It is not, because I just decided to add it right before we signed on. But
yes,
I can type them in. Thomas, why don't you talk for a moment
Okay.
about whatever you want?
Well, I don't have the slide show up. I'm just waiting for Nancy. So maybe go to the next slide and I'll riff it.
and we'll go back as we go.
Okay. So Sarah has taught me there's something called trauma-informed communication, but I was pleased to hear from Sarah that I already do it anyway. I just had no idea what it was called. So, be a nice human being, be empathetic to what's going on with your person. And of course you'd want to do that, but it's also at the same time, and this is me talking and Sarah might clean it up. Sarah mentioned that it still has to be reasonable, even though it's this person's individualized objective experience, but it has to be reasonable. And lots of folks, particularly if they're in a toxic or dysfunctional or unequal, awful partnership dynamic, they have a different perception and they're triggered by things that you or I would be like, what's the big deal? But it's important to them. And but of course, as practitioners, when we're advancing their cause, whether it's in settlement discussions, just chatting with the other side, trying to work something out, or before the court, we have to look through the lens of what the court is seeing. Does that seem ridiculous to the court, even though to this person it's certainly not? It might. And then we have to use some we have to be very good with our client management. Sarah's put up the case sites, and I don't know if you want to clean that up, Sarah, because I don't know how trauma informed that was.
I will come back to trauma informed in just a moment. Can we go back to the other slide just so I can get the last of the basics out of the way? How common is domestic violence? Much more common than anyone probably thinks. 1 in 4 women are going to experience some sort of intimate partner violence in their lifetime. 3 people on average a day are killed. And the thing that is most important, I think, for everyone to take away regarding the statistics is that if an individual has been strangled, their lethality skyrockets by, I want to say the last number I heard was 700%, that when you are leaving an intimate partner violent relationship, that is the most dangerous time for survivors, and that increases if they are pregnant at the time of separation. So if your clients are pregnant or have recently had a child at the time that they are coming to you, whether that be for a protective order or a family law case, they're in an increased sense of, or an increased place of lethality or danger. We can go back to tips for working with victims now. So the way you handle your clients in your office is going to be very different than how you have to handle them in court, because as Thomas said, the court is going to see one thing and they're going to be making their decisions based off of the observations that they're making. They're not going to have the experience that you do of all of the information and the different ways that they could present. So sometimes I'll have clients that seem like it doesn't faze them at all, that they're not upset in any way. And that somewhat hurts their credibility, because if you're sitting there very calmly explaining this traumatic, horrible, violent interaction between you and your partner, and you're just sitting there talking about it as if you're talking about the weather. So it's important to know that you have to work with your client to make sure that the correct information is getting out in a way that is impactful to the court. Other times, we'll have clients that are very emotional, and it doesn't seem to match the story that they're telling. They seem to be saying something that might be somewhat benign to us, but it goes with everything that has happened before. So one of the classic coercive control examples is somebody would just give their partner a jacket or a sweater before they go out to remind them that you're going to want to cover your arms, because if you don't behave, then I'm going to hurt you when we get back. So it doesn't have to be a threat. It could be a look. It could be a specific touch. It could be reminding them of an event or handing them something. So in the courtroom, if the person does something specific, like if the defendant pats their arm or gives them a certain look, that could trigger your client. And so you also need to know when to take breaks. As far as working with them in your office, it's important to validate them, validate their current emotions, and validate their experience. Try and empathize with them. We were always in the DV world taught to empower survivors. The time that they're coming to you might be the first time that they are trying to stand up for themselves and trying to take back their power, trying to take back control over their lives. Also, it takes about 5 to 7 times of trying to leave before somebody will leave their abuser. So if they feel like they're not being heard, they're not being supported, that the road forward is too hard, then they're going to go back to the hard that they already know, which is their abuser. So you want to make sure that you hear them. Now, it is not always appropriate in your intakes to let them tell their entire story all at once, but it is going to be important for them to tell it to you and for them to feel like they're being heard. I often invite them and give them the option of either writing it all out for me, because then I'm not interrupting them with questions to make sure I understand. They can write it as long as they want. They can edit it as much as they want before they hand it to me, or that they can sit down and talk to me. But I make it clear that that has to be a separate, specific session for that. Because especially if you're trying to file a protective order or an emergency custody hearing or something like that, you need to be focused. But give them as many options as possible. I know that's our job anyways. But you might want to break those options into smaller chunks for victims of domestic violence or survivors. Okay, so also if you're going to be working with survivors, you're going to want to make sure you're familiar with grounding techniques. There are some very basic ones that everyone can just use wherever you are. That's the breathe in 4 times, hold it, breathe out, counting to 10, looking around the room and choosing 3 things that are blue. Some people have fidget spinners. But you want to make sure that you talk to your clients at the beginning to know what their grounding techniques are, or what has worked for them, what doesn't work for them, so that you can remind them to do those things in the moments where they are starting to react when you want them to calm down. You should make sure that you're building in extra time into all of your sessions with your clients, especially during the initial intake and trial prep. They're going to need, well, they won't all, but several of them will need extra breaks, whether that be to collect themselves, to work through their emotions. Sometimes they want to check in with their therapist. They will also need things broken down into smaller chunks. Trauma affects the ability to remember and to process, so be prepared to repeat yourself. I personally sometimes get frustrated with that, but just remember, their brains have been altered by the trauma, and so they can't always hold on to things the way that you or I could. I don't give any of my trauma surviving clients big tasks. So for example, with discovery, which isn't protective order, it's family law, but discovery, I don't send it out and ask for all of it at once. I'll say, why don't we focus on the interrogatories today? Or I need these first 5 interrogatories by this day and these 5 by this day. And you break it into smaller chunks because it seems more manageable. Well, it is more manageable and it's less overwhelming.
I also will enumerate tasks, which looks a little teacher-like, pedantic. Number 1, do this. Number 2, and then it also cues me, don't go beyond 3. And they not up to that, but it's chunking.
I also find it very helpful with all clients, but specifically clients that are survivors, to have them repeat back to me what their goals are the case, what we discussed, what their homework is for the next step. That way I know we're on the same page or where our communication gap is. I put a lot more things in writing for my survivors than I do for other clients, because again, memory is an issue for some of them. And it's also a good way to, just CYA, which is always important. Also, I highlight progress with them. So sometimes they feel, I'm sure all clients feel this way, but I experience this more with my survivor clients, where they feel like they're just spinning their wheels. They're not getting anywhere. The other side is still getting everything. They're not getting anything. They're not being heard. The court isn't kind to them. So it's important to highlight where things have improved for them or what the next step is and what that's likely to bring for them. So that's a very, very brief how to be trauma informed and work with clients. That could be like we could take an entire week seminar in that.
Sarah, I just wanted to make a point that, to the mentees online, is that these cases are extremely challenging, and these clients who come into the fold and are in need of legal help are already their trust has been jeopardized, their ability to, as Sarah mentioned, to hear and listen and to understand has been jeopardized. And it takes a really, really patient attorney and someone who understands what this client is going through in order to really be a good advocate for that client. So, think about that before, sometimes some attorneys just aren't capable of taking these kinds of cases. They just don't have the empathy to do so, or maybe they have been, it's triggering for them due to some other issue that they may have had in their past. So just be very careful when you're looking at these clients and you're thinking about taking them. Reach out to those who, such as Sarah, who does know more about these types of cases, and make sure that you were very well prepared before you move forward with these unfortunate cases.
I put a practice pointer into the chat, and I just want to make sure I'm not misunderstood. We're all very empathetic. Everyone who's on this call, I'm sure, is the same way. Otherwise, you wouldn't be working for MVLS. You wouldn't be taking this training. I have found, and I don't know if other people have found this also, that because these folks are in a very delicate situation, they're traumatized, they've been victimized, certainly according to them, and probably true as well. They just really need you more, and they're looking for you to come in and really bust some heads, and they want you to, it's more likely that they want you to align with them, which means you're really not being, you might not be seeing this more objectively. And if you don't, they're gonna get, it's more likely that they're going to get really upset, and they don't want to be victimized by their own lawyer. And so they can turn on you. That's all I meant by that. I mean, look, a lot of them are amazing human beings. They're just in an awful situation. And when you're in an awful situation, just a word to the wise. Hopefully that chat wasn't misunderstood.
Before we go on, just a couple of things I forgot. One, I try not to use the word should with any of my trauma survivors, because that could feel to them that I am telling them what to do and I am taking away their choice. So I like to make sure I phrase everything with choices and options. I also like to have, I assign them more homework than I do my general family law client, so that they have an idea of what they want to talk about and what they actually want from whatever session we're working on. So if we're working on mediation, which we will talk about related to domestic violence in a moment, I'd have them do lists in advance so that I know where I can push them and what triggering topics there are. So again, it's just really important to break things into small groups and manageable tasks, but please be also prepared. There are some that are on the opposite end where they want to talk for 4 hours straight, and that can be exhausting for you as well. So don't forget to set your own boundaries. Trauma victims generally don't have great boundaries, so you need to make sure that you are setting very strong boundaries for the case, not only for your own mental well-being, but also for the ability to perform the service that you are retained to do. Okay, we can go on. So filing for an order of protection or a protective order, I'm not sure how many people will do that through their MPLS work. They might outside. I know that I've had several protective orders within my family law cases that I've done for MPLS. Where, when, and how to file. So you can file a protective order 24 hours a day, 7 days a week, 365 days a year. The commissioner's office never closes, and you can file a protective order there at any time. However, if the courts are open, they much prefer you to file in either the district or circuit court. There are some commissioner's offices in the state that will not accept a protective order petition during court hours. Others will. But technically, if a court is open, you are supposed to go to the court. Courts usually stop accept filings for protective orders about a half hour before the end of the day. So an interim protective order, that's going to be when you file with the commissioner's office. I think we have a separate slide for that. Yeah. Temporary is when you file directly with district or circuit court. And the final is, well, we'll get there, but district or circuit court, which one do you file in? That is going to be a very case specific choice. There is some strategy to that. As a nonprofit attorney, I always prefer when people filed in district court. It gives you an automatic de novo right of appeal to circuit. So it was just always helpful. If I didn't get everything as quickly as I needed, I got another shot. But that's also unfortunate if you are representing the petitioner and the respondent takes advantage of that and you have to redo it and then re-traumatize the client to get the same result. The other advantage to district is if you do get an order in district, and let's say it was by a trial or a merits hearing, well, a trial, and it gets appealed, it's not always to have another trial. Sometimes it's so that the other side can consent. And we'll talk about the advantages to consent in a little bit longer, or in a little bit. Petition for protection, very simple, straightforward form. You can see it on the screen. When you're filing a petition for protective order, you do have to use the court forms. You cannot write a motion. You have to use the court form, and you have to fill out the addendum. Now, there is also another, yes?
That's interesting. I never knew that, but I've never, well, like, why would I be filling that out, right? But I don't know if anyone else didn't know that, but I never would think to type it up in the first place, but I didn't know that was the rule.
Yeah, I've never seen a court accept one that wasn't on the form. It might be in the Maryland Rules 9300 section. I know the waiver of appearance has to be using the court form. And I believe the rest that's in that as well. But there's also an addendum, which is what the sheriff's office uses to identify people to serve. So you have to make sure you fill out both. You can go to the next slide, because we're going to talk more in depth about these questions as we go along. So at the very beginning, we went through basic examples of abuse, and I didn't really harp on any of that because you all can read. Abuse defined 4501 under the Maryland Family Law section. An act that causes serious bodily harm. So we're talking about broken bones, needing to go to the hospital, stitches, being stabbed, things like that. It could also mean bruising though. So anytime there's an injury, the court is going to say there was abuse. Well, I shouldn't say it that way. I'm sorry. Anytime that there is an injury, you now have evidence that there may have been abuse, because there are things such as self-defense, mutual aggression, and other things. An act that places a person in fear of imminent serious bodily harm, the key word here is imminent. A threat that is conditional or in the future is not a threat for purposes of a protective order. It is not imminent. If somebody is in California and they're threatening to harm your client here in Maryland, that is not imminent. However, if they're at the airport getting on a plane, you can make the argument that would qualify. Assault in any degree, that includes the any threat of assault. This is where like punching a wall next to someone's head, saying, "I'm so angry, I wish this was you," that can be used as a ground, as an act of harm, either assault or fear of imminent serious bodily harm, to get a protective order. Rape or sexual offense, those are all defined by criminal law, and the sections are there for you. False imprisonment, that is when you do not allow someone to leave an area. There is no minimum amount of time that you're blocking someone. So if you block someone into a room and there is no easy escape, let's say you're blocking the only door, that's false imprisonment. Now, if they have another door right behind them and they can walk out, it's not false imprisonment. But if the only other exit is through a window or something like that, false imprisonment. Stalking, that's a very specific definition. I encourage you all to read 3802. They have expanded it in the last few years to include intentional infliction of emotional distress. But it does require a course of conduct or a pattern. Most judges that I've gone before have required at least 3 instances before they would consider a pattern or a course of conduct to have occurred. Please note that harassment is not a ground for a protective order under Maryland Family Law 4501. So a lot of people would come to me saying he's harassing me. That is unfortunate, but a protective order cannot stop that. Well, you cannot obtain a protective order for harassment. A protective order will stop harassment though. And lastly, revenge porn, that's the most recent ground that was added. There's a lot of technical definitions that go into that, but you can't distribute someone else's pictures without their permission. And that doesn't matter whether it's in person or electronically, you can't distribute them. So we can go on to the next slide. So there's also peace orders. You can file for a protective order if you're currently married, you were previously married, you're related by blood, adoption, you have a child in common, you're cohabitants, meaning you've lived together for at least 90 days or more in the last year, and there's been a sexual relationship. If you've had a sexual relationship in the last year, even if you're not living together, if you're alleging a sexual assault that occurred within the last 6 months, I think those are all the big ones. If you don't qualify for a protective order, you qualify for a peace order. So those are going to be your neighbor disputes, your coworker disputes, the random person walking by the street every day that you go to work where they're yelling at you. There is no intimate relationship for peace orders. I'm not going to go too much into peace orders, but there are some major differences. Peace orders are only good for 6 months. The abuse or the grounds for the peace order had to have occurred within the last 30 days, and you have to prove that it's likely to occur again. A protective order, on the other hand, lasts for a longer period of time, and you do not have to prove that there's additional abuse that is likely to occur again. That is going to be different than in family law cases when we talk about abuse and ask courts to find specific findings, which we'll get to in a little bit. So interim protective orders, that's when you file at the commissioner's office. They're good for 2 to 3 days. They are ex parte. It's reasonable grounds. I think that's the next slide. Yeah. yeah, so all of the, let's say we still had snow today, your interim protective order, if you had one from this past weekend, would still be extended until court reopens. So they're typically good for 2 to 3 days, but it's until the second business day that the court has reopens.
Sarah, how would you tell people that if you were speaking to a client that what is reasonable grounds?
So reasonable grounds is the judge just has to believe that what you were saying could have happened. It's the incredibly low standard. The court pretty much just has to believe that you're credible and that you're not lying. You don't have to produce much evidence. Now, if it's a contested TPO, that's different. You do have to produce a little bit more evidence. Oh, sorry, I went to TPOs, but interim protective orders, the commissioners will almost always grant interim protective orders, even when they shouldn't. So
I'll chime in on the TPO on that issue of
yeah,
reasonable
so
grounds.
we can go on to TPO now, because interims only a commissioner, they're somewhat common, but they don't really matter because they're not it's not guaranteed to go anywhere after that, and someone isn't even necessarily served by the time they get to the TPO. They matter because they do give immediate relief, but again, a protective order isn't in effect until it's been served by law enforcement on the respondent. So if we go to the next one, TPO, TPOs are good for up to 7 days, and or well, typically they're good for 7 days. They could be good for up to 6 months if good cause is shown. So protective orders, you have to be served before you can get to the final. Good cause is often that we can't find the respondent to serve them. If that's the case, there is a form that you can fill out asking the court to waive the petitioner's appearance until the respondent has been served. You have to have them sign up for VineLink, which is a program that was started in Kentucky. Lots of states use it now. The person signs up with their case number, their name, and the respondent's name, and they get notified when the person is served.
You sound like you need a voice break. Another reason that Sarah knows, and then there's probably other reasons, sometimes there'll be a DSS report or CPS report, depending which jurisdiction you're in. So the court obviously wants to hear from DSS and the report so they have enough information. And that they work very fast, but it could take weeks, especially if one or more of the material people are difficult to get a hold of. So that is another reason why it will be rescheduled. There might be others, but hopefully that
yeah, and that's a good time to point out. I don't think we had it on our 4501 slide. Child abuse is a ground for a protective order. Neglect is not. And so in Maryland, corporal punishment is legal and allowed. But when punishment is exceeded and it becomes abuse, you can get a protective order on behalf of the child. And that's when DSS or CPS would be involved. Thomas is right. That's one of the more common reasons as to why a protective order would be, a temporary protective order would be extended for good cause. Other reasons, attorneys have requested it. They're trying to work something out. If you need a necessary witness, such as law enforcement, that would be another reason to extend a TPO. I'm not sure if all jurisdictions are like this, but in my experience, police have a different amount of time in which they require you to subpoena them before they'll show up. That isn't necessarily consistent with the subpoena rules and how much time you're only required to give under the law.
AKA the law.
So I know one jurisdiction in particular, you have to give the police officers 10 days notice as a minimum. And they still aren't guaranteed to show up. So that's a reason why you can ask for a protective order to be extended to be able to get the police officer there.
So when this, I put in the little silly pictures, and one of the reasons I did the scales is obvious, but the other reason is because this is from a public policy perspective, the judges really, and the law really does a balancing test here. So when you're dealing with IPOs or TPOs, they're temperate. One of it says so. And the goal is to protect everyone, get everyone, broken up for a little while. And it is a huge infringement upon the respondent, particularly she didn't do it, but it's only for a couple of days in the IPO situation. If they even know about it, well, we'll see. It's only for up to 7 days, maybe longer in the TPO. But on the other hand, you're protecting the victim or potential victim from abuse, which of course is awful. And the reasonable ground standard, even though I asked the question, I didn't know if there was some magic language to it, but I had the opportunity many years ago to work for then Special Master Chris Panos when they were called masters, and he was Special Master because he was assigned by the Baltimore City Circuit Court to be the only one to hear all the TPOs. So that happened during my clerkship, and he never once, we maybe at least 5, sometimes 10 a week, maybe more, never denied a TPO. And we had a special group in Baltimore City in the court that triaged, helped the victims present better. They did a fantastic job. Now, of course, this also occurs at the district court, and one day all the district courts were shut down. It was called medical services. They were overrun. We were just getting these petitioners with no triage. So the stories were markedly different, and His Honor was finding any reason he could to grant the TPOs to include, and I'll say the story fast because it's funny, and why not? We're going to be here for 3 hours or another 2.5. This lady thought her husband was cheating, and he was. She follows him to a motel. She peeks in the window and sees him having sex with, for whatever reason, she knew was a hooker, sex worker. Or both, no quotes, sex worker. So she decides to go back to the house, and she's in a rage, and she destroys the house. I mean, she says, I broke everything I could. Lots of cuss words in the middle of the story, which is interesting. I destroyed everything. I broke everything that's important to him. And then I see him pull up. So I turn off all the lights and I hide. And then he comes in and sees everything broken. He's like, what the? And then when he passes by me, I jump out and go, ah. Right. And then he turned around and punched me in the face like I was a man. Okay, yeah, because you just, I forgot to tell you, they were doing coke, he and the hooker also. So she knows he's on coke. She destroyed his house. All the lights are off. Obviously, it's a B&E. She scares the hell out of him. He punches her. And then, so I don't see any domestic violence yet. And I'm wondering how His Honor, what he's going to do with this. She walks out into the yard, and he's screaming at her, cussing her out. And then she decides to walk back up the stairs towards him. And then he pushed her again. And he said, thank you, stop right there. And then in a very calm voice, he explained the situation, noted that the tensions had de-escalated. And then after the de-escalation, the respondent did in fact assault the petitioner. And I was TPO granted, reasonable grounds. I got a couple other stories, but I don't know if we have time for that. So, the court was supposed to make sure everything is fine. And then 7 days later, everyone can tell their own story, and we'll see if it's in fact abuse or not.
Yes, one of the reasons that reasonable grounds is the burden for temporaries and it's so low is because they're emergencies. The legislature is assuming the person filing is in a heightened sense that they don't have the time to have gathered all the evidence that they need, that they're just trying to get immediate relief. And so the court will oftentimes grant temporaries that don't necessarily make sense to us as attorneys, but that is just to get everything to settle down. And they will always have an exact reason as to why they're doing it. So it's never just like, yep, you can have it. They will always state why. In fact, on the protective order, they have to give a reason and what the ground is that the protective order is for. Just to expand on reasons to file in circuit and reasons to file in district. Yes, there's always the appellate reason. If there's an open family law case, it should go to circuit court. And if not, you're likely to be transferred there. That's another reason. Temporaries can be extended for good cause. If an open family law is in circuit, then the district court doesn't want to deal with it. They will transfer it to circuit. Same parties, same children, same issues, circuit court should handle it. Alternatively, the circuit court could transfer a protective order to district court. I personally have never seen that, but they could. And just a few more differences with peace orders. Peace orders must start in district court. They will only go to circuit court on appeal. So if you have a peace order, you must file it in district court or the commissioner's office. And you cannot extend a peace order for lack of service with a waiver of appearance. The petitioner must come back every week. And at max, it's 30 days because the abuse has to have occurred in the last 30 days. Okay, we can go to final. Final protective orders. These could be as little as a half hour. I have had protective orders that lasted 2 days though. So I think there's a common thought amongst practitioners that protective orders are quick and easy, and they're not always. So the biggest thing is, one, make sure that the respondent has been served, and then two, know your judge. Knowing your judge will be very, very helpful in a protective order, whether that's actually a temporary or a final. But in a protective order, the person who testifies has to be the petitioner. They must testify at some point. I have, on very few occasions, been able to get protective orders without the petitioner testifying. I don't recommend trying to do that. So the petitioner is going to testify, any witnesses that they have. So maybe officers responded, maybe the officer has body cam footage, maybe they were on the phone with their mom or a friend, a neighbor heard or saw. Any witnesses that you have or any corroborating evidence, it is important to bring to the court. There are times you might want to hold something back if there is an open family law case and you don't want to give them everything right away. But again, protective orders are for safety. They can be up to 1 year, and I'm going to expand on that momentarily. But so you do want to give as much information to the court related to their safety as possible. Burden of proof goes up to a preponderance of the evidence. So more likely than not, what the petitioner is saying happened, more so than what the defense or respondent is saying. It is a higher standard, but it's much lower than clear and convincing, which it used to be. When I started doing protective orders so very many years ago, it was clear and convincing as the burden, and the courts were treating that almost the same as beyond a reasonable doubt, which made it really hard, especially for pro se victims, to get protective orders. So that has been reduced to preponderance of the evidence. Additional evidence that you might want to try and bring forward for a protective order: pictures. Pictures are very helpful. Text messages, social media posts, broken items. All right, what relief is available? So the relief in a temporary is very similar to the relief in a protective order, and I failed to cover that even though it was on the temporary slide, so my apologies. But in a temporary protective order, it's not to abuse, threaten to abuse, and to harass. There can be limits on contact. There can be limits on where a person can go. All of that is expanded in a final protective order hearing. So not to abuse or threaten to abuse the petitioner and any of the minor children potentially. Doesn't have to include the minor children, but it could. Limits on contact, you can be creative in this. You can set whatever boundaries or parameters are necessary to keep the petitioner safe. So I've had cases where it's been absolutely no contact. I've had cases where it's no adverse contact or no unlawful contact. Each judge is going to interpret that slightly differently, but play nice. So I've had judges explain it as, you can't curse at the other person, you can't yell at the other person, you have to act as if you're talking to your grandmother. So each judge will have their own examples as to how they explain it, but generally you have to play nice. Then you can also do things like, you can only contact each other during these certain hours, or you can only contact each other about these certain topics and it must be in writing. I strongly encourage you to limit contact in a protective order to be in writing if there is going to be any contact. That's all just going to be evidence, whether you need that to extend your protective order, modify your protective order, or you need it for your family law case. It protects both parties too. So I have had a lot of respondents counsel tell me they don't want everything in writing, but it's protecting both parties. And also, if you don't want all of your communication in writing, what are you afraid of? What do you think it's going to show? So if they're going to have contact, because there's minor children involved, I recommend having a set time, it being clear what time that call is going to happen and who's initiating that call. So protective orders, if you violate them, they do come with criminal charges. So it's important to make sure you're setting up any contact specifically with the children in a way that is not going to potentially violate the respondent. So one easy way to do that is the petitioner initiates the call at a specific time per the order for the children to be able to talk to them, or ideally have a phone just for the children. You can have stayaways from the home. You can have use and possession of the home. Use and possession in a protective order is different than use and possession in a family law case, which Thomas can speak to more, but use and possession in a protective order, you don't have to be titled on that, and you don't have to be married. So it doesn't have to be your property, but it does have to be your residence. So you can use in possession, you can have them stay away from a school, stay away from an employment place of employment, stay away from a daycare provider. A lot of people think that there are distances. Unless a court is willing to include a distance, there is no term to say 100 feet away, 200 feet away. You can order the respondent to counseling. You can get use and possession of pets, jointly titled vehicles. You can also receive emergency family maintenance. Emergency family maintenance is not specifically child support, and it's not specifically spousal support. It is monetary support meant to maintain the stability of the household during this brief time of a protective order. And I say brief because at most it's generally a year, though it can go to 2. We'll still talk about that momentarily. There is a separate financial form that you should fill out if you're asking for emergency family relief. As you guys know, in family law cases, we do short forms or long forms, depending on what people are asking for and how much they make. They have a domestic violence specific one for protective orders for emergency family maintenance. If you come to court prepared, yes, Thomas?
Where can they find that form? Is that also on judiciary website? Easy to find?
Yes, it's on the Maryland Judiciary website. I'll have you talk momentarily, and then I'll find it.
All right, I'll do that right now, because we were going to talk about know your judge, and I know that if I could see everyone's faces, there'd be some eye rolling or head nodding, and it's very important. There are judges who are not open as maybe they could be to granting protective orders. There are judges who are very protective and judges that fall in between. Right? I mean, everyone has their horror stories depending on which jurisdiction you're in. Sarah has more horror stories than most. And if you get a judge who doesn't want to grant a protective order, depending on which side you're on, I know we've pretty much only talked about the petitioner side, but if you're on the respondent side, hey, congratulations. Maybe you take it to trial when you otherwise would have consented, or maybe you work out a deal that is a little bit more favorable to you or has less terms than would otherwise be the case. But there are also some judges who are more protective, I'll use that word, and you have to consider that as well. Might be one reason to not take it to district court or not take it to circuit court if you're wily enough to figure out who's on the DV docket that day, which could change, but generally it starts off as this judge has a DV docket or not on this day. Similarly, when you ask for a brief postponement, that's kind of an advanced move there, but if whoever you have for the TPO, when they schedule the FPO, you might want to have that information. Not always available, but certain judges have a different, or let's call it, some people have a more modern view of corporal punishment. Some people have a more traditional view of corporal punishment. As I already mentioned, I clerked in the circuit court for Baltimore City. I actually did 2 clerkships there, and it's different. I had one judge ask an attorney which part of the belt was the parent using to strike the child, and when it was determined that it was not the buckle, the judge shrugged. Okay, I didn't know that was an option to get struck with a belt buckle, but I guess so. Similarly, if they're protecting children, some judges, maybe they had a family law background, know more options that they can bring into the order, are more tuned to how domestic violence between parents affects children. So very important to know your judges. Do your homework if you don't know the judge. Certainly ask local attorneys, maybe even attorneys who practice it nonstop, like the DV attorneys at YWCA, Hartley House, House of Ruth, Hope Works, etc. All right, I think I've talked that to death.
I put the link in and the form number in the chat. Emergency family maintenance, going back to that, if you come with child support guidelines, the court will consider that. Please note that you cannot double dip. So if there is already a family law order for child support or spousal support or undifferentiated support, the court will not also grant emergency family maintenance. People try that a lot. It's one way to really annoy your judge. And when Thomas was talking, Thomas, that's actually a very common question, which part of the belt was used. In knowing your judge, though, also know which judges need the bloody photographs to be willing to grant one. I've had judges look me straight in the face and tell me they don't believe domestic violence is a thing. So just, make sure you know who you're talking to. And lastly, the other relief that's available is there is a catch-all in the protective order statute. And this has been talked about in case law, including Castanel and Bogan, and that is the court needs to grant whatever relief is necessary to protect the petitioner. They should not only do the minimum that is necessary, but they need to grant whatever relief is necessary to protect the petitioner. And so that gives us as lawyers a lot of flexibility to add in terms that make the clients feel safer. So I've done it where parents can both go to extracurricular activities, but one person gets this side of the field, one person gets this side of the field. We've done it where we've staggered church times, because the court will never, even though it's a very common request, the court will never say somebody cannot go to a place of religious worship. However, you can work it out that this person gets to go to the 9 a.m. service and this person gets to go to the noon service. So that catch-all is very helpful in structuring agreements. Now, please note that if you're trying to give a very detailed, almost family law-like order through the protective order, that will annoy a court. So I encourage you to consider other options, such as extending the protective order while you try and figure out a more in-depth order. We can go to the next slide. This is going to be Thomas's slide because I don't defend abusers. As Thomas said, I spent the majority of my career representing victims, so I don't defend abusers. I will defend respondents if I believe that they did not actually commit the abuse, though.
Yeah, that's our deal. So, okay. Sometimes it doesn't happen. It's true. And sometimes abuse didn't happen. And it's sad that the petitioner brought it up and did all this. But it does. I don't know what the percentage is, and I don't even want to try. It's not a lot, but it does happen, right? And we as family law lawyers get to know our clients, and next thing you know, there's a DV case, and sometimes it's for alternative reasons, and the judges know that. So what evidence can we use to show something did not happen? that's tough. We could examine the person's motives, timing, the fact that there's a case going on in the family court. I mean, it's relevant, but which way does that cut? So I've seen lots of different defenses, including mutuality. I was about to write mutual combat, but if there are two aggressors, why would a judge label one of them as an abuser, which carries a lot of stigma? Sometimes, once, at least, well, more than once, I had a neighbor who had a real jackass husband, but her FPO was turned down because she was a very feisty, strong woman, and she told the judge, "I'm not scared of him," fill in the blank, lots of curse words. The judge said, "Okay, well, then you're not in fear." Of course, you can try to impeach the person on the details, especially if you can show contradiction. If there's third-party witnesses or video that go your way, regardless of what side you're on, that's very valuable, right? Same
I'm
thing.
going to interrupt you for 1 second.
Sure.
He is right that judges won't grant protective orders if fear isn't involved, but it's not a requirement. If there was an assault, that is a ground for a protective order, and the judge should not care whether the person is afraid or not, because the underlying incident was an assault, and that is all that is needed. The only time fear is needed is if it's being granted on fear of imminent serious bodily harm. But it is common for courts to look at whether the person is afraid of the respondent or not.
Yeah, of course, I agree with that. I've also seen instances where the judge got that confused. Or if there was mutuality of words, but only the abuser got physical and physically assaulted. But of course, I agree with you. But it can happen. Be careful of that. And I'm not advocating putting forward incorrect law. I'm not, but it could happen. I have seen, this goes along with what I'm saying and Sarah's saying, subsequent acts by the petitioner could controvert what she is saying, that whether abuse happened or whether there's any fear at all, especially lots of text messages from the petitioner. And I'm talking about after the TPO, because you're probably not representing someone in the TPO, but certainly after the alleged assault happened, is the petitioner calling all the time, texting all the time, requesting to meet up, physically showing up at your client's house or place of work. And that doesn't mean that the abuse didn't happen, because this person, the victim, is in an awful dynamic. But if you're defending the respondent, it could demonstrate that what the victim is saying didn't happen to the degree, or in the case where it's not an actual assault, she's not in fear. I'm just going to keep using he, she, but we know the percentages on this. So that is, those things can be very relevant. Also, you can impeach the person by their past conduct, their past filings. I had a case where this woman kept filing on my client, and the last time she was in court, I didn't represent my guy. That's not what happened. When I got her on the stand, she admitted that her previous filings, of which there were 3, did not happen. Those things did not happen. So I started asking her more questions, and the judge stopped me cold and said, "Counselor, you know what you're doing right now, and you have to stop. I heard what she said. I will not let you ask any more questions. And ma'am, you're done. You're off the stand. Your petition is denied. We don't want to talk about what you just admitted. Have a nice day." So, it could be that, of course, you always use impeachment, right? But but it still comes down to he said and she said, so, or she, he, whatever. So both sides have to be very detailed to overcome the presumption that, both of them are saying what makes the difference. I don't know if anyone has any questions on that, or if we want to take it offline. The last 2 bullet points, why consent? So for those who don't know, if the respondent has the right to consent to the entry of the protective order without an evidentiary hearing and without a finding of abuse. There's no abuse. The respondent's just saying, okay, I agree to your relief. And again, that's a whole balancing thing. So public policy says, fine, we'll do that because the victim is protected. No finding of abuse, no evidence is even heard. So that can be powerful. The same time, that'll be out there. And unless someone takes a close look, they'll just see that you have a final protective order against you. And there are lots of reasons not to have that on your record. Security clearances, we all deal with that around here. I don't think you're going to be coaching anyone's soccer team anytime soon, and you might have a hard time chaperoning a field trip. But there's that, but you certainly avoid all the drama, you'll save a little bit of money if you have a lawyer, but it's a certainty. One could try to get the petitioner to agree, and we'll talk a little bit more about this in options, to vacate, just dismiss their petition, but put in the protections in a custody or divorce case. Is a lawyer needed? That's a tough one. And
Thomas, before you go to lawyer, can I interject on consent? There's a couple of the reasons to consent. One, if you have criminal charges. So protective orders cross both realms of civil and criminal. And so if you have criminal charges, you're not going to want to say anything on the record without at least having spoken to your criminal attorney. Additionally, it is not uncommon for state's attorney's offices to send people in to hear what is happening in a protective order, especially if they're very interested in prosecuting that protective order. And there is a benefit to consenting. If you consent to the final protective order and you do not violate it, you can have it shielded. So it will be removed from the public record, but the courts, police, and the parties can always see it. And domestic violence agencies will always be able to see all protective orders.
And just take affirmative actions to get it shielded, right? But it can be.
Yeah, you still have to file the shielding, but you no longer have to have. It changes what the shielding hearing looks like. So if you don't consent and it's dismissed or denied, then you can file either a waiver saying you won't sue the petitioner for their pleading leading to the protective order, or you have to wait 3 years and then have a hearing, and you have to say why it's better for you, and that outweighs the public need to know about it as to why it should be shielded. However, if you're found by preponderance of the evidence to have committed an act of abuse, that is never shielded. So in the cases where it's more likely than not pretty clear that abuse occurred, you're better off consenting to it because then you can have it shielded. One problem with what's up, Thomas?
I was going to say, look at you. That wasn't so hard to come out of your mouth. Good job.
Yeah, I don't know, Thomas. I feel a little ill now. It's also important if you're representing survivors to note that the respondent can consent over the petitioner's objection. So there are some people that are going to want to let the court decide. They want to tell their story. They want to be heard. They want it all out there. Petitioner doesn't get the choice. Respondent gets the choice as to consent or not. And that can be very frustrating for certain clients. So you might need to do some extra letting them express themselves after. So in cases where you have clients that like to talk, that are trying to empower themselves, trying to take control back, trying to find their voice, make sure you set time aside after the case to help them process. So yeah, that's all I wanted to add for consent.
I don't have much more to say about is a lawyer needed. I think that what we should do is basically tell them everything that Sarah said, which was most of the counseling, and then what I said, because it's their risk. And yeah, Sarah, I don't know what you think about this. If they're just going to go in and consent, that's still tough. There cannot be a hearing, but I have seen there's a bit of wiggle room on the relief. And Sarah, so I'd like you to talk about this, but if the petitioner checks all the boxes and the respondent consents, it should be consenting to everything. But then there's, within reason, right?
So I would say yes, sort of. So I have definitely appeared in front of judges who do that. If it was checked and that's what the petitioner is asking for, that is what this final consent will be if you were consenting. And I've had other judges approach it as this is a negotiation, just like any other consent would be, just like if you had an attorney present. And they will go one by one. Do you agree to this? Do you agree to this? The times that I think the things that most people argue about, whether it's with an attorney or without, it's access to the children, amount of money that has to be paid. And a lot of people don't like to stay away from the house. So it can be a negotiation. If there's no children involved and it's a straight stay away, then easy consent. I don't think lawyers are needed. But if there are details that need to be worked out, you're either going to be having a judge do it for the parties on the record in front of everyone, where people just say yes, not thinking things all the way through big picture. And then you have complicated, messy protective orders that have to be amended or modified. So if there are children involved, I think attorneys should be present. It's just cleaner and easier for the future.
We're ready for the next slide. Of course,
Okay.
if anyone has questions on or offline, but
I actually want to skip this one to do violations first, and then we'll talk about alternatives. So violation of protective orders. It is a crime. The first offense is up to 90 days in jail and or $1,000 fine. If you're found to be a subsequent offender, so you've already been convicted once, it's up to a year in jail and or a $2,500 fine. And the thing to know about violations of protective orders is every contact that is in violation of the protective order is its own violation. So if it's no contact and somebody texts you, the victim, 20 times, that is 20 violations. Now, the state's attorney has the absolute right to make that one count. And so what happens in those cases where somebody's constantly going over and harassing, and 20 texts this day, 15 calls this day, 30 emails this day, they'll lump it and they get a charge per day. But it's important to understand that each of those violations is its own violation that could face the 90 days or year, depending on what it is. There is a case, and I can't think of what it is right now, where the guy was convicted of 18 violations for 18 different phone calls. So violations can come with criminal charges. They don't have to, but they can. And it won't be just the violation of the order. If it's an underlying offense, they can be charged with that as well. So protective orders, one of the terms that you can include is no harassment. If the person is harassing the victim, there's been a reasonable request to stop and they're continuing, the respondent can be charged with harassment or misuse of a telephone, as well as a violation of a protective order. So those underlying charges often come with higher jail sentences. How often people actually go to jail depends on what jurisdiction you're in. When a violation of a protective order happens, not only do you have the criminal to look at, you can also modify or extend your protective order. So you can modify your protective order at any time when there needs to be a change. That could be because it's not working. It could be because you want to give the victim wants to give the other side another chance or give them more leeway. There is not the requirement that there be a substantial change in circumstance like there is in the family law. So if you want to change something about your protective order, you have the right to ask the court to. The court does not have to agree to modify your protective order. The court also does not have to rescind your protective order just because you ask for it. And I think we talk about rescissions later, so I'll come back to that. But you can modify your order or extend your order. To extend your order, you need at least good cause. If you have good cause, you can get up to a 6-month extension from the end of the order. So if your order expired this coming Friday, it would be 6 months from this Friday, even if the hearing was today. Now, if you file for another act of abuse it can be up to 2 years, and that depends on lots of different circumstances. But it could be up to an additional 2 years, and that's from the date of the hearing, not the date of the original expiration. If you're going to file an extension, you have to file it prior to your current one expiring. And that extension hearing has to happen within 30 days from the initial order expiring. The order is automatically extended by law to that hearing date. There is a rule that says that the courts should issue a new order with that extended date, but they're not required to, because by law, it's automatically extended. So I have one right now in circuit court. The court didn't extend it, they didn't issue a new order, but her order is in effect until the hearing date in February. Also, I said we would talk about the lengths of protective orders before, and we didn't. So initial protective order up to 1 year. However, if you are filing a protective order within a year of your last one expiring, and that one that just expired had been good for at least 6 months, you qualify for a 2-year. Lastly, there's something called a permanent protective order. Those are very rare. Those are very hard to find or obtain. And permanent protective orders vary from final protective orders because it's contact provisions and stay away provisions. Nothing related to custody, emergency family maintenance, use and possession. None of that will be included in a permanent protective order. Other types of protective orders that there's an extreme risk protective order. A gun has to be involved and there has to be a mental health issue. Those are usually brought by police, so I'm not really going to go into those very often, but that's usually when there's some sort of mental health crisis. Okay, so what can be done if the abuser does not comply with the order? Again, modify it or extend it, criminal charges. This is different than in a family law setting, which I think Thomas will touch on momentarily, hopefully. Oh, yeah, Thomas, that's on this slide, so I'm gonna let you talk about that.
Before Thomas takes over, can I ask a question, Sarah? If a family law, if a final protective order is denied, and shortly thereafter, in the case I'm thinking of, a week or two after, new allegations surface, can that petitioner file another
Yes.
protective order?
Anytime there's a new act of abuse, you can file a protective order.
Okay.
So, and that is something that I should have mentioned. Anytime a court is looking at a protective order and anytime there's a protective order hearing, the court must look at all prior protective order and criminal filings between the parties. And that is different than in a family law case where you have to get all that evidence out separately. The court's going into a hearing knowing that the statute says they shall look at all of these cases, and the court has a form. You probably won't see it very often, but the court is given a form by the clerk that says this is the case number, this was the decision, this is the case number, this is the decision. And so they have that on top, like that's one of the very forms that they have in their MTech filing.
Thank you, Sarah. Appreciate it. Thomas, before you begin, I have a thought. Do you want to take a break now and then move on? And I was thinking about breaking at 10:30, but we can break now if you would like, and then come back.
Sure, that'll give folks a chance to do whatever they need to do, although we can't see them. And then get questions together. Yeah.
All right, let's take a
time for my second cup of coffee.
Yes, indeed. 5 minutes, everyone. We'll reconvene at
I'm gonna try to beat Sarah there.
5 after 10.
Yeah, well, I'm gonna get the better coffee than him. I'll be right back.
Okay. All right, we're back.
Okay, so we were talking about violation of protective orders, and then now I'm letting Thomas, and by that I mean I'm asking him very nicely because that sounded really horrible. I'm sorry. I'm asking Thomas to do how it differs from family law cases.
The violation?
Yeah, how do you enforce them?
Gotcha. Well, the biggest difference is that, so let's say that the same provisions or something similar was in a family law case. The biggest difference is a violation is not, it's not a crime, obviously. Maybe not obviously. So you just cannot go that route. You do not have that stick to enforce that. You could file a contempt. It's also a breach of contract. You should file both. I think the court will take it pretty seriously. The problem is when we're doing a violation in a civil matter and in these domestic cases, there has to be a purge. There has to be some way to make it right. And if the violation is, so we're talking about if there was a, let's say, a stay away provision or non-disparagement, or a don't post nasty things about me on social media term, what do you do with that? You can file for contempt. You can file a motion to enforce the contract. You can get attorney's fees behind the motion to enforce the contract, probably contempt as well. The purge, I guess, is to take it down if it's a social media post. One might say the damage is done. If it's a disparagement, a verbal threat, etc., you know, judges don't usually order people to apologize. So, but so it's very hard to enforce compliance and deter future non-compliance if it's just in a family law case, other than attorney's fees. But there are qualitative effects on future proceedings. So if this happens during the pendency of the case, you're obviously going to bring up in, as far as it's relevant, whether it's to fitness as a custodian, or perhaps it rolls into a course of, and a pattern of conduct when it comes to reconcilable differences and facts that led to the breakup of the marriage for a monetary award, which also is a factor for alimony if that's part of your case, which it's usually not in our MBLS cases. So it is relevant, it's probative, it could, depending on how significant it is, if it's prior abuse and it's certainly subsequent abuse that's non-compliant with the terms of a family law order, is relevant to custody. It's one of the enumerated factors, and I'm going to talk about that briefly. I know it's mentioned on a future slide. So I think I'm overlapping with a future slide. Can we go to the next one? And Sarah probably needs a break. Oh.
There we go.
Well, no, we're gonna go back because remember I skipped one. So if we could go to alternatives to a protective order,
Gotcha.
that one. Sorry.
There we go.
So from a respondent side, obviously it's not good to go forward with the DV case if the facts are against you. If there's multiple witnesses, if there's video, I mean, you don't want to have to represent someone who says that's not me on the video. I mean, it's funny, but it's not going to work. So that's when you consent. Looking at the different options we have. So I'll start and Sarah will finish. If you're a respondent, representing a respondent, hopefully no one's a respondent, you could consent, you could go forward and try your luck. I tell my respondent clients, you're either going to lose or you're not going to lose. You're not going to win today. The best you can do is not lose. So remember that. Maybe you want to consent, but it depends on their circumstances. Or we'll certainly see if they'll put all the terms that they want into a family law order or a custody order and hopefully make it temporary, or PL, which could save you both money. So now another option is an out-of-court agreement. Just don't go forward with the DV at all and put it into a contract, which on the one hand is ridiculous if you're a petitioner, because there's very little enforcement. But the petitioner and his or her attorney could just could attach that and seek to incorporate that into a family law matter. An out-of-court agreement, it needs to be a very unique circumstance. You're probably trying to protect security clearances. You're hoping that, it was I don't want to keep saying unique, but an unusual one-off situation, and which does not excuse it, but it's not likely to happen again. I don't, Sarah probably agrees to some degree, but I don't like to consider those, but it's possible.
Out-of-court agreements aren't the greatest option, but they have been useful in certain situations. So for clients that want to get back together with their abuser, just putting some sort of boundaries in place has sometimes worked in the past. Usually it will lead to a violation and a new protective order within a couple weeks, but sometimes it works. The time that I've used it the most, and I think might increase in the future, is when they had immigration concerns and they didn't want to be in court, or at least not be in court longer than necessary. And that also depended on what jurisdiction I was in as to whether coming to court was as big of a concern as it was in other counties. But that's probably where those are the two most common times I used an out-of-court agreement. So we would dismiss. Sometimes we would put the agreement on the record. Sometimes it was just an agreement between the parties that would be written out and they would both sign it. Otherwise, I think most of the time we did it either in a court order through a protective order or through the family law case.
Sarah, I haven't seen that many orders from the court that are just simply mutual stayaways. What I mean by that is when the burden of proof was higher, clear and convincing, whether the judges were going rogue or not, I don't know, but sometimes they would deny the petition, and then order a mutual stay away. I haven't heard or seen of that.
So clear and convincing changed
recently, but
a long time ago. There are specific rules as to when they can find mutual aggression and when they can order mutual stayaways. I have, what I see more often than not is the petitioner agreeing to also not contact or not harass, just so that they can get the rest of their order, which gives them the protection that they're looking for. Because a lot of times clients will be like, I have no desire to talk to him. Yes, I will agree to no contact just to get the rest of it. So most of the time that I've seen a mutual no contact or stay away is when the petitioners agree to it just to be able to get the rest of their order. But for a judge to be able to order it, there has to be at least one protective order still standing. I've seen it happen in agreements where dismiss the protective order against me and I'll agree to no contact under yours. But if a judge is going to order a mutual without the agreement of the party, there have to be two orders.
I have a question for Sarah as it applies to when is best not to go forward with the DV case. Is it, if the petitioner, let's say hypothetically, she gets a judge that she knows is very not open-minded to the concept of domestic violence, and she says she wants to say, I don't want to go forward because it's going to be denied. I know, hopefully everyone knows, you can dismiss your own petition. Can she refile on the same incident?
Yes. So protective orders are dismissed without prejudice if the party fails to appear. If evidence and testimony has been taken and a final is denied, then it's res judicata and you need new facts to be able to go forward.
A crazy scenario. Are you saying that this petitioner, upon seeing that her judge is Judge X, can just leave the courthouse, therefore she has failed to appear?
Yes, and
her ability.
Her order will be dismissed.
Will she preserve her ability to refile on the same incident?
Yes. So I've had clients who, for whatever reason, weren't able to get to their hearing. And first, if you have a client that has that issue with the judge, hopefully you've already tried to change the date and or transfer to another, maybe you're in district and you want to transfer to circuit and you've tried that. But if they do not show and no evidence and no testimony has been taken, then they can refile. The court is going to want to know why they didn't show the last time though. Now there are judges out there who will deny it and say it's res judicata, in which case you need to appeal.
Maybe I might be presenting this in a way that is a little concerning for everyone. How much of a problem is this? How often does one get a judge that is so either protective or dismissive of the protection that that this really matters? Is that something the people in this should look out for?
So I can't speak to all jurisdictions. In the jurisdictions that I worked primarily as a DV attorney, 5 to 10% of the time.
Okay.
But I would strongly encourage, especially if you're going before a court that produces their DV calendar in advance, to check the calendar, not only as to when you're going to file for your client, but for the dates in which you're asking for a postponement, if you're in a jurisdiction where you have a judge that does not believe in domestic violence and routinely dismisses them or denies them. I will say that courts have the judiciary has increased the amount of training that judges must take when it comes to trauma-informed care and domestic violence. And I hope that issue is becoming less prominent than when I was a baby attorney.
All right, so maybe I should move on to impact of alternatives in family law cases. I think I talked about that, but not the sub.
No, before you get to that, Thomas, did you talk about the difference between an emergency order and a protective order?
I didn't. What I'm thinking is, to me, they seem entirely different because protective orders have to be based on abuse or threat of abuse, or one of the enumerated factors in 4501, whereas an emergency in a custody or divorce case, that's a little bit deeper water because, and I think we talked about this in the first training, because each jurisdiction, county, has their own informal internal definition of what constitutes an emergency. And if it was abuse, as defined under the statute, it would be faster, probably more efficient, and get you defined relief by filing this as a petition for protection from domestic violence. But some emergencies are not abuse and therefore would not qualify for a protective order. And in different counties, for example, in Howard County, a complete inability to see your children or something really close to nothing is considered an emergency enough to get you at least an expedited hearing, a couple weeks or so. Similarly, if you're getting no financial support at all, same thing. It could be an emergency to the client, such that they feel that it's abuse, financial control, etc. I don't think most judges will see that as abuse because they don't want to stigmatize the respondent with the scarlet letter of abuse. So,
is there any time in which you would file both the protective order and an emergency custody?
that's a tricky one because, in my opinion, as a matter of practice, because the DV judges, let's say it's district court judge, they're very likely to not want to touch it and transfer it to circuit court sua sponte, because the circuit court can handle all that, which the circuit court could also handle the DV, which is what the judge would say. So you also, now sometimes it's a strategy where you say to your client, I'd rather file only the DV because we'll know within a few days, up or down on custody, emergency family maintenance, etc. And I can draft the emergency petition to the circuit court the very next day. However, if the DV petition is denied, that certainly won't reflect well on your emergency petition in the circuit court, which is not meant to, it's not a protection from abuse filing. I don't know if that makes complete sense, and I welcome questions or redirection on it by anyone. Looking at my little chat thing over here. So if not, I'll go forward and you can pull me back. The granting or denial of an FPO will inevitably come up during your divorce or custody case, depending on how you or the other side wants to use it. If you have a denial doesn't necessarily mean it didn't happen, but you didn't meet your burden and it's only preponderance. So, but if you're representing the respondent, you don't want to take that too far, because it doesn't mean that the petitioner was lying. It doesn't mean that the petitioner is vindictive and trying to ruin your life. And if that's your perception, that could be very telling to the court as well, particularly when it comes to, can this person, the respondent, was the respondent, communicate and cooperate well with the person who was the petitioner? Let's just use stereotypical gender. If he is so angry at her for her filing that he thinks that she's subhuman, or she's just a lying, so that'll backfire on you. If you have some proof that that the petitioner knew what she filed was false, well, that's different. That's a character issue. We frequently have had this, but Sarah and I just had it last week, where the respondent counsel kept making a huge deal. Oh, it was denied. She's a liar. She's trying to destroy the family. This guy even went right outside the courthouse and made a video and put it out on social media about what a liar our client is. And this is a victory for all men. I'm going to show my kids. And then he did. He sent that video. So he really overplayed his hand. But, and I don't say that in like a haha, we gotcha. It's just relevant, probative, perhaps even determinative of what type of co-parent he is. And his behavior thereafter certainly was the same. So if it was granted, you can bring it up, but you have to still talk about the underlying facts. You have to put the facts into evidence. You can't just say, take judicial notice this was granted, because it's just preponderance of evidence, and the family law judge may see it differently. Probably not, but you have to put the facts in for whatever purpose. And that, now on the other hand, if your FPO is granted in the circuit court by the same judge you're in front of for the custody and divorce, you still have to do it, but you're going to get a lot of nods, and here the judge may cut you off and say, I'm familiar, which you would say, well, I need to build a little bit of a record, right? But that would be one reason why, if your case was really strong and you knew it was going to be part of a divorce case, why you would file the DV in the circuit court. Similarly, if you're going to get a custody evaluation, et cetera, et cetera, et cetera, courthouses are small places. A lot of information is public and appropriate for the custody evaluator to look into. So that's that. Sarah, do you want to expand on that, or?
No, I think some expansion might happen in the next couple slides.
Gotcha.
We can go to the next one. So in family law cases, you're almost always going to be ordered to mediation, but not if you click that little box that says either a party or a child has been a subject of abuse. And so is mediation appropriate with domestic violence? There are two very, very contrasting thoughts on this, but it depends. And it depends on the individual victim / survivor. So the courts will not order And sometimes even if you request mediation with a victim or survivor, the court will decline to order you, which means you don't get the court ordered rate, which is unfortunate. But generally, no, they're not going to mediate. This will also be important for settlement conferences, because you have to go to a settlement conference regardless of the domestic violence or not. In certain jurisdictions, they'll do the settlement by Zoom so that you don't have the in-person risk. However, if your client really wants to mediate, despite their domestic violence history, then you need to make sure that they feel that they have bargaining power, and equally bargaining power at that, that they have the ability to say, no, I'm not agreeing to that, that they won't be manipulated into agreeing to something they don't want. So this comes back to one of those very first slides where I talked about coercive control. If the person wears a certain shirt or says certain keywords, that might trigger your client to go back to that domestic violence situation where they aren't going to be as empowered as they are entering mediation in. So you have to make sure that there's boundaries, that they are actually comfortable, that they can't be easily triggered. This is where grounding techniques come in. You could work with their therapist to make sure that they are in a place where they can do this and participate in a meaningful way. Advocating for themselves becomes harder and harder until that switch flips. But even so, even when they are in the place where they finally feel like their voice is being heard and they're empowered and they want to have a say, they can slide. It's all a spectrum, just like everything else. So it has to be their choice. They have to understand the risks, and they have to really understand that they should not sign anything in that first mediation session and without their lawyer reviewing it. I've had many clients who have, especially when I was working for a nonprofit where we didn't do family law, they'd go to mediation and I'd be like, don't sign anything. Don't agree to any, don't sign anything. They'll be like, yes, I'm not going to sign anything. Then they come back having signed something because they felt pressure to do so. Also, if my experience is that some people, when going to mediation, when they're not truly ready, don't feel that the mediator is neutral, and then they start to distrust the whole process because they feel like the mediator is trying to push them towards what the abuser wants and aren't listening to them. And no, objectively, we know what's actually happening, but mediation is going to could cause your client to backslide and further harm your ability to move the case forward if they aren't actually ready to participate. So I generally only do mediation if my client really is emphatic that they can do it, that they know what they want, that they have their 3 lists. These are my absolute yeses, these are my absolute nos, and here's my wiggle room. If they don't know that going in, I don't mediate with a victim of domestic violence because they're too likely to be able to be pushed into something, especially because in certain jurisdictions, lawyers aren't welcome to the first mediation or the custody mediation. And you really need to do a lot of prep work with your clients if you're not allowed to go to mediation with them. And so I always like to make them write those 3 lists. And then I push them on them before they go into mediation. So Thomas, you think you want to say something?
Just a couple of things. Minorly, a minor thing. We don't know the dynamic, and there could be things that trigger a client that we don't even know about. And Sarah had a client from HopeWorks that later came to me, and there was a twitching thing that her face used to make, and it's, the abuser, and he certainly was, would use the word twitch or make his face twitch, and that is absolutely triggering because of the horrific violence that she was subjected to. But there could be certain words or incidents, and the abuser's just bringing them up, and I don't know what's going on because why would I? The larger point I wanted to make, when it comes to mediation, all the Zoom stuff we're doing nowadays, post-COVID, I've gotten a lot of pushback from magistrates and judges, more so in certain jurisdictions, but they say, well, what's the problem? It's over Zoom. and you could, or would he or she do it if it was over Zoom and you were present? I mean, well, counsel, how could she possibly feel threatened? I don't think that's even appropriate for my client who's a victim of domestic violence to hear that. But you have to advocate for your client and tell them in advance, talk to them in advance. Would you feel okay with that? Okay enough, but then you have to be very careful. You don't want to pressure him or her. So that will be something you'll hear, because the court really wants people to mediate, really wants people to settle. And sometimes the court is less empathetic to the dynamic and the violence or abuse that your client has endured, and they will push the mediation. You can say no. And you could say something like, well, Your Honor, because she's represented, I, of course, will be doing everything I can to work with the opposing attorney. But mediation, whether Zoom or otherwise, is just not appropriate here, given the dynamic between the two, which, as you know, resulted in a filing for protection from domestic violence, which is an understated way of saying, what are you doing? So it's important to know that's going to come.
You can also always ask a caucus if the client really wants to mediate but doesn't feel comfortable being in the same space. Caucusing is a good tool. Also, if you're going to, whether it's mediation or family law case in general, if your client previously worked with a domestic violence agency, you might want to consider getting a release to speak with them. They will have the whole history of domestic violence. And that is helpful for two reasons. One, your client in theory will have already told you during intake, but the domestic violence agency is going to have the full file. You won't have to ask the client to go back and find police reports and pictures and witness statements. So it'll save you time and money. But more importantly, it's not asking the client to relive all that prior abuse that happened before they came to you. And if they already have in their intake, you get to compare them, and sometimes there are additional details that they remembered 5 years ago when that event happened. So releases with other prior service providers, including their current therapist, can also work. I don't think I said this when we were talking about being trauma informed, but I usually encourage my clients to schedule additional sessions with their therapist during trial prep and during discovery, because those are the two times that we are asking them to relive everything in a truncated timeline. Sorry. So additional sessions, even if they're just brief check-in sessions, I've found to be very helpful on keeping people focused and being able to process while not going backwards.
I thought of something as I'm looking at the participants' names. Doing either side of the domestic violence cases is often an area where newer attorneys cut their teeth, where they get a lot of experience. Of course, you can determine your price point. It's a great way to get very good at litigation. And I remember when I was first starting out and I worked at the circuit court, we worked with the Women's Law Center, the Protection Order Advocacy Representation Project. That's all they did. And some of these hotshot Baltimore County, Baltimore City lawyers would come in and they would tell me, because I was the master's clerk, like, look, I do a lot of litigation. I've been doing it 20, 30 years, but these ladies, they happen to all be women, they do that every day, all day long. And yeah, and you don't want to lose to them. So but on that point, it might be a great idea if you can find the time to go in and watch some of these. Of course, there's an attorney, it's better. You can learn a whole lot in a very abbreviated period of time, because FPOs don't usually last that long. Sometimes they do, but very rare. Well under 10%. I would say well under 5%. So something to think about when, if you want to build your practice on that. I'll leave it there.
And yeah, protective orders in the nonprofit situation, I've done as many as 13 in a day. So you'd get to see a lot if you sat through a docket. Okay, I think we can go on to abusers during litigation. Thomas, you want to do this one or you want me to? I can.
So this abuse is usually about control or fear, but it's, comes down to control. And Sarah's already explained that when situations in flux and the abuser's losing control, they can be most dangerous. But they're going to behave the way they behave because that's just in their nature. So there's going to be little tells like this. But I just write these down because you should expect that, and you should think to yourself, how will you handle that? And you should get your client ready, although she knows because she's been dealing with it. So you can also use these traits to the extent that they substantially come out in court, to demonstrate to the court, this is what she's been dealing with. So don't take it from me, don't take it from her, just take it from him. Look at how he's behaved, look at what he said, look at etc. But you need to know these things in advance, and maybe you already did, but so that you're prepared, and you need to prepare your client. But we need to prepare too, because we're human beings and we can get triggered. And sometimes it's all we can do to just maintain our professionalism. At the same time, you're trying to highlight the behaviors to the court. It's tough. So these are some of the things you will deal with. To include, I shortened these up, but Sarah wrote something more than may try to control the space. That means physically, and cheesy men do that. Or like, oh, shake your hand too hard, or they talk real close. That doesn't bother me. I'm not a tall human. I don't care. But if it doesn't bother you, it doesn't bother you. But expect something like that, because they're abusers. So they're not going to be respectful of you either, but certainly not of your client. I summarized it, and I don't know if it's even necessary to add detail. But
some of the things I've seen in protective orders and family law cases, but in protective orders, is that the respondent's going to try and stare down the petitioner in court. So I've had sheriffs block their line of sight before. I have made sure that I was blocking line of sight before. Also, if you're going to represent in a protective order, more often than not, the judge will allow the petitioner to testify at trial table so that they don't have to stare out into the respondent. So that's something you can consider as well.
And we've coached our clients also. If we don't feel we feel they can be upset, you don't have to even look. You don't have to look at him. You don't even have to look at his attorney when they ask you questions. You can look at me, you can look at the judge, you can look at your hands. But yeah, standing in the way of the sight line is a very, I don't want to say common. I think it's a good move. So I don't think, well, it's not common because I don't see a lot of other attorneys doing it, but some do. You could even stand in the sight line of the opposing counsel when you're asking questions. You shouldn't, but you probably should stand in the way of the sight line of the respondent, or maybe his buddies that are in the gallery, because it's going to be very upsetting for your client. But you prep him or her in advance that this is the deal. So it's a great point, Sarah. And
you don't need to be afraid of your client reacting or having emotion on the stand. Sometimes it shouldn't be a constant thing, because that, I think, also will lose some credibility. And you can ask for breaks. A lot of judges, in my experience, will know when a break is needed and won't even ask if they want. Well, some will ask if they want one. Others will just be like, all right, we're taking a break. So you don't be afraid to ask for breaks when the abuser is behaving poorly. All right, so next slide. Should a petitioner rescind their protective order? And this would come up for a couple of different reasons. The one that's probably most relevant in this setting is whether they should rescind their protective order into a family law agreement or family law order. And whether they do or do not, like everything in the law, it depends. You have to consider several things before advising or helping them make a decision. Why did they get it in the first place? Was it an incredibly violent episode? Is this the only thing that is keeping her safe in this moment? Was it more just to kind of settle things down? Now they're in a better place, less restrictive order or agreement would be appropriate and still may achieve the same goal. Can you put the same relief in a family law order? Is the other side willing to do so? What length of time are they willing to agree to that? So protective orders have a set expiration date, somewhere between 6 months to 2 years, depending on where you are in the process. Family law orders don't necessarily have an expiration, but you have to consider, is it a temporary order that the parties are agreeing to and filing into the family law case? Is it part of the PL order, knowing that it's going to be changed at the merits? Or is it a consent order that is staying in the case? So sometimes having no expiration is more important than having the additional teeth of having a criminal violation if there's a change. If there's a violation. You have to consider what the benefits are to rescinding and if there is another alternative. So when clients would come to me and say they want to rescind their protective order, I would see if there was a way we could modify their protective order to give them the changes that they want while still keeping them protected. If you're trying to enter a family law order, then that's not going to work. But if it's just a straight protective order and they all of a sudden want to rescind it because they want to get back together, I would encourage you to modify it to a less restrictive order before rescinding and see if that works. Also keep in mind that judges do not need to rescind an order, even if it's because you're entering a separate order with the same relief. In the incredibly violent cases, I've seen many judges say, no, he or she came for a reason. I heard this case. I saw the pictures. I am not rescinding this order early. However, there are times that rescission is what's best for the family. That could be because somebody's going to lose their job with a protective order. Maybe that's because their job requires a gun, which is absolutely terrifying, but there are ways that could still be safe. For example, I did rescind a protective order for someone whose partner was in the military, but they had to check their gun before and after their shift, so they were never allowed to have a gun off base. I don't like rescinding them when somebody needs a gun because that's just sketchy in my opinion. But military people often need guns while on duty. I will caution you against military protective orders. I've had several clients, both in protective orders and family law, say, it's fine, I have a military protective order, I don't need a civilian protective order. Here's what you should know about military protective orders. They're only in place until their commander says they aren't. There is no set timeline. There is no specific reasons why they are or are not kept in place. It is up to the individual's commander. So if that commander changes, then the terms of your order could also change. So anytime somebody feels the need to have a military protective order, I also believe they should have, or at least consider, a civilian order. You might also need to rescind it for security clearance. My experience with security clearance is if the person, the respondent, is honest with their job and says, hey, this was filed against me, and they get out in front of it, it's generally not a problem. It's when you don't tell them and you wait until your security clearance is rechecked and then they find out that you lose it. Additionally, consenting usually does not result in somebody getting in trouble for their security clearance. It's the finding of the underlying abuse that is problematic for security clearances. And lastly, before rescinding, you should consider how long the protective order has been in place. Because again, if it's been in place for at least 6 months, if there's another act of abuse within the next year, you can file again and get a longer one for up to 2 years. So I think that, did you have anything to add to that, Thomas? Do you see any other?
No, I do think you covered it. Sometimes the respondents, police, that's tough. No, you did. You covered it. No one likes the concept of rescinding a protective order because, as I often say, the law is already that she can't abuse you. So what's the problem? Like just follow the order. But I get it that can be situations for the job, but
The only other thing is sometimes it helps figure out the remainder of the terms of the family law case. It might buy you some goodwill. Not saying that's a reason to rescind on its own, but if your client's going to get all the other terms that they're seeking because you're willing to get rid of your protective order, then yeah, you should do that.
right, you can leverage it. I don't mean that in a manipulative way, to avoid things like you could get all the PL relief resolved. Boom, no more PL hearings. Your client saves thousands of dollars and lots of emotional costs because PL is supposed to maintain or reestablish the status quo anyway. So assuming that that's agreed upon, the respondent probably wants a different new status quo, and I don't blame them. But status quo, there'll be time later for that. So yeah, if your client can get protection and something that settles the waters and calms the situation, which might calm down the respondent and eliminate a lot of the anxiety that was the cause of his totally inappropriate abuse. But I'm not excusing it. I'm just saying.
Okay, next slide. Making agreements with abusers.
I did that one. We're just saying, hey, look, this is who he or she is, and without a lot of therapy time, the first step is admitting the problem, right? Then you should expect this person to keep doing what he or she's doing. And if anyone doesn't know the fable of the scorpion and the frog, you do a quick Google search. It's fantastic. There's also a really great scene in Natural Born Killers where someone talks about the same situation with the rattlesnake. But anyway, not the only reason to watch that crazy movie. So expect them to behave in conformity with who they are.
Which is another reason why when somebody wants to rescind it, I try and get them to have a less restrictive protective order before just rescinding it. So step down, let them continue to show that they can follow and that they have changed. I lost my train of thought. Because it takes, I want to say the social science said that it takes 6 months before someone can show actual change. So a week or two in, yeah, I'm sure they're regretting their choices and they want things to go back to normal and they don't like that they've lost control, but you can't show true change that quickly. And what was the other thing? So we talked earlier about how you can order someone to counseling through a protective order, and those are abuser intervention programs. Abuser intervention is not the same thing as anger management. Anger management is you don't know how to control your emotions. Abuser intervention, that's about control and how you shouldn't be trying to control your partner. And it's way more in depth than that. But abuser intervention programs have to be approved by the court. So there is a list. Almost all DV agencies have a program for abusers attached to the other services that they provide. But please note that abuser intervention is not the same thing as anger management. Most abuser intervention programs are 26 weeks long. Okay, we can go to safety planning. When should you have a safety plan? Always, everyone should. Abuse or not, everyone should have a safety plan. The easiest way to think of a safety plan is everyone knows what a fire drill is and the escape routes for that. It's the same thing. You should always know where your exit is, what the closest exit is, and what if your closest exit is blocked for some reason, how else are you going to get out? Abuse victims should never be furthest from the door. They should always be closest to the door. They should always have their keys on them, their phone charged. Often people have a go bag, so in their car, change or two of clothing and all their necessary paperwork. I actually recommend people storing that with a friend or a family member, someone close by that they can always go to. I have one client that keeps it in her desk at work. But it needs to be someplace that the person doesn't have access to, the abuser doesn't have access to, and that they don't know about it. Safety planning isn't just one safety plan. You should have safety plans for every situation. If it's, you should have one for work, home, court, which we'll talk about in a moment. And it doesn't just have to be about your physical safety plan. There are agencies that work on financial safety planning. So we didn't really talk about financial abuse. That's not a ground for a protective order, but it will come up in family law cases. And then there's emotional and physical safety plans as well. You can involve your children in a safety plan. You need to be careful as to how you do this, because yes, safety is the most important thing. However, courts don't want you going into too much detail with your children. But there are keywords that parents give to their children so their children know either to run to the neighbor's house or to call 911. As far as court goes for safety planning, you can call the sheriff in advance and ask for an escort to and from the car, both for you and your client. In Howard County, the practice is the survivor is always the one closest to the door and the respondent is the one further in the room. If there is domestic violence involved in a case, they will often bring in extra sheriffs into the courtroom or the bailiffs, depending on which court you're in. And those are all things you can plan for ahead of time. Yes, Thomas?
Don't be afraid to ask for that. Whether you're a woman who knows Krav Maga or you just think you're a tough guy, don't be afraid to ask for that. A larger sheriff presence can diffuse things or deter things before they happen, which is what we want. I mean, on the one hand, you might be like, yeah, let him go crazy. And, you don't want that. And similarly, remember that most of the violence that occurs in court cases occurs in family law cases. It's not criminal law cases. When I used to work at Baltimore City, the saying was, criminal law is bad people behaving their best. Family law is good people behaving their worst. Their emotions go nuts. They do crazy things. The sad situation with the judge from Hagerstown was a result of a custody case and the husband followed him home. It happens all the time. You just don't risk it. And it might be a little awkward, but that's the job of the sheriffs. And depending which jurisdiction you are, they're probably happy to do it. Get it, and also depending how cold it is outside. But do it. If there's any inkling, concern, suspicion, do it. Ask in advance for extra protection. And I've had settlement conferences in jurisdictions where they'll employ small rooms for these settlement conference rooms. Okay, fine, in normal situation. But you can ask for them to use, if possible, an empty courtroom where there's more room and, it's better for your client. There's ways to get out and have a sheriff present. Next.
Here in Howard County, if there's a domestic violence situation with a settlement conference, we're either in a courtroom or we're on Zoom. They won't use the small rooms. But you should definitely let the sheriff or bailiff's office know in advance, especially if there's been no prior domestic violence filings, because then the court has no notice that this is an issue. And we haven't really talked about that, but there are lots of reasons that a person wouldn't have filed or given any notice to the court in any way that they are a victim of domestic violence. People don't go forward because they don't want their kids to be taken away. There's this concern that by allowing domestic, and I say allowing, but by being a victim of domestic violence and having your kids exposed to that CPS will come take your children. That's not a very common thing. Immigration reasons, people won't come forward. They don't want criminal charges brought for the other side, so they don't want to come forward. They think it's their fault. They're not ready to leave. They think it's a private matter. They don't believe what their experience is abuse. So there's all sorts of reasons that somebody isn't going to file the protective order in advance. But after you've done that intake and you've done your own assessment for domestic violence, if you think that safety is a concern, you should let the sheriffs know in advance. You should also arrive or have your client arrive early so that they are not arriving at the same time as the abuser. If stalking is a concern, then they should not drive to court. They should have someone drop them off and pick them up. Otherwise, the abuser potentially has unsupervised access to the car to place a tracker, or they can follow them home. So you have to consider what the abuse is and curtail your safety plan to that. Now, I don't think most law practitioners are doing safety planning with their clients. And you don't need to in great detail, other than maybe when you're in court. All the other safety planning can happen through your local domestic violence agency. Every county has their own agency. We're going to get to that on the resource page, but every county has a place for your client to call to safety plan. If not, they can call the Maryland Network Against Domestic Violence or the National Network to End Domestic Violence. They both have hotlines. They both can safety plan. They can both give resources. So you don't need to feel like you have to figure this out. There are definitely resources that you can refer your client to. And under VAWA, I believe all of those resources should be free. All right, so we skipped 9101 and 9101.1 findings. So I don't have a slide for this. But if you have a family law case and abuse has been alleged and or there's already a protective order, you can ask the court, well, they have to either way, but you can specifically bring it to the court's attention that you're seeking a 9101 or a 9101.1 finding. So, yeah.
Statute, not rules, but you
Yes,
probably
sorry,
could figure that out.
statute, Maryland Family Law Statute 9101. In a custody case, if the court has reasonable grounds to believe that a child has been abused or neglected by a party to the proceeding, the court shall determine if neglect or abuse is likely to occur again, unless they make a specific finding that there's no likelihood of further abuse or neglect. The court shall deny visitation. Now, they can arrange a supervised visitation setup, but again, they have to make a specific finding that there is no likelihood of further abuse or neglect of that child, or they cannot give access. And then Maryland Family Law 9101.1 extends that a little bit further, and now it involves abuse of a party. And that requires.
But that's also how you would use a finding of abuse in your family law custody case, if it's a finding of abuse against children.
Yes.
So it's very difficult for courts to make a finding that it's not likely to happen again. That again, courts obviously best interest is paramount. They don't want to take that risk, especially at the PL stage. But especially, as Sarah already mentioned, there still could be access with the respondent abuser, but it would be supervised.
And 9101.1 expands a little bit because now it's involving abuse of a party, where this somewhat relates to the language in the domestic violence statute, Maryland Family Law 4506, where the court has to create an access schedule to protect the victim of abuse, whether that's the party or the child. I think the last slide is just resources. You want to go to that one, and then we can see what we missed. So yeah, every county should have their own dedicated domestic violence agency. Some of the smaller counties, I think, do share. House of Ruth covers lots of different counties. I mentioned Maryland Network Against Domestic Violence. That's the nonprofit that oversees all of the other, well, it doesn't oversee them, that connects all of the other DV agencies. There's also the Sexual Assault Legal Institute. So that is the Maryland Coalition Against Sexual Assault. They provide lawyers for all sorts of cases, actually. They are much, they offer cases or attorneys for protective orders, family law, employment, criminal, all sorts of things if you are a victim of some sort of sexual assault. They might do a little bit of human trafficking as well if it relates to sex trafficking. I already mentioned the AIP courses. Also, it's important to note that most counties, or at least most counties that I've worked in, I shouldn't say most counties, but the counties that I've worked in have dedicated sheriffs, police, and state's attorneys units just for domestic violence. And so you have people that are in most cases choosing to work in that unit. And so hopefully that means they're more empathetic and will be more patient with your clients. Here in Howard County, the state's attorney's office has victim witness coordinators that are specific to domestic violence cases who will sit through every hearing with a victim of domestic violence. Protective orders, there's Maryland People Law Library. That's always a good resource, whether that be for domestic violence or other family law matters. And then at the bottom is the National Network to End Domestic Violence. They have 24/7 hotlines, and they are super awesome because you can do it by phone, chat through their website, text, or AI. And I know here in Howard County, HopeWorks has a 24/7 hotline as well. You can call at any time, ask for housing, ask for somebody to talk to, ask for a safety plan, ask for resources.
I should have given a shout out on this to Women's Law Center, of course, because they do an amazing job. They have a hotline also. They create, for example, they staff the Protection Order Advocacy Representation Project. They also have something called Adobe, which has to do with folks who don't speak English, new to this country. I also want to mention that you can refer your client to these places, and they'll do a fantastic job, perhaps at the TPO, at the FPO, if finances are a concern, which they are for everyone, but especially our MVLS clients. They'll do a great job. They're excellent attorneys who, we're not allowed to say specialize, I'm going to do it anyway, who specialize in this all day long, every day. You heard Sarah say she did 12 a day sometimes. So, and you can get a release from your client, and they're a fantastic resource if they come over to you for the family law case to bounce ideas back and forth and get information and insight to the client. In fact, that's how Sarah and I met. And then the last point I want to make is most of these places, maybe all, I just don't know for sure, have other resources. Sarah started to talk about that, to include group therapy, just group chats, of course, shelters, big thing, food pantries. I don't know how much health access that, but they'll help you. So they even have groups for kids. So, you know, it can't be understated how traumatic domestic violence is on the victim and on the children. So all of those resources are available, probably needed for your client, whether they use them or not, but usually free. So.
And I guess well, maybe not the only other thing, but an additional item is that domestic violence organizations may also be able to reduce the financial burden when it comes to criminal advocacy as well. So I know when I worked for those agencies, I worked very closely with the police department and the state's attorney's office, and I could advocate for my client in the criminal setting, help them write their victim impact statement. So those are all things that the domestic violence agency can do so that that your client's bill is not increasing, and everyone can still be on the same page. And that's very important for all of the orders to be on the same page, whether that's protective order, family law, or criminal/probation order.
And I should mention that, I keep forgetting, for the respondent side, you know, people can rehabilitate themselves. People can get better at being a human. A lot of these places that are listed here also offer men's groups, not that they're necessarily respondents, fathers groups, respondents groups, anger management training, and Sarah can talk about a lot more. They usually go by a euphemism such as new behaviors. I don't know if that's even around anymore, but that's really important too. We're going to represent respondents, and they deserve to be represented, and hopefully we can help them do better, a lot better. And some of these agencies can help with that.
And I don't think we made it clear, but whichever order is later in time is the order that is taking precedence. So if you get a protective order that has custody, your family law order that has custody is superseding the custody provisions of your protective order. The stay away and the contact provisions will remain intact in your protective order unless specifically addressed in the family law order. So if you get a PL order that changes the custody schedule, the PL controls, but the no contact is still going to stay in place.
And you're going to want to bring that up at PL. So, because ideally the court would incorporate those terms into the PL order. Instead, your client's, trying to show police two different orders. And similarly, if something happens after that, subsequent, and then the domestic violence order, again, public policy is to protect people, that would supersede. So it's not that circuit court orders trump district court orders. It's, as Sarah says, it's whatever is first in time, noting that you could probably modify the circuit court order anyway. But I'm happy to take questions on that or anything else, but that might be a little confusing.
Yeah, and I might have skimmed over some stuff, but I tried not to go down any rabbit holes or nerd out on you guys. So if you have any questions, let me know.
I have a question. Do you have a sense of what the percentages of men who were afflicted by domestic violence?
I can tell you from my experience, about 8% of my clients were men.
I would say it's probably at least double that, but they don't report. And for lots of, even doubling that, it's only 16%. But there's also the whole, like, if your wife smacks you across the face, you might deserve it. But let's say it's still assault, right? But how many men are going to go? But if a man slaps a woman across the face,
Yeah.
wow. So there's, there's still a stigma, and it's also where you are. I mean, some of our more rural counties, I wouldn't want to have to, bring a guy in there. And there's also even though, as Sarah already said, assault is assault, whether you're in fear or not. But if you're a big guy, and there are some women who are like really big and muscular or just small and just like they've won all these martial arts competitions, okay. But that's a tough one.
So according to the statistics I quickly found, 1 in 3 men will will experience some sort of intimate partner violence in their life.
That is only those who report, I assume.
Right. So that only 1 in 10 actually report an impact. But their rates of experience are just as high as women. Women come forward more frequently based off of this quick Google search. So I can't say that definitively.
Right.
I can. So yeah.
It's important to believe them and empathize with them the same way. Some men are in same-sex partnerships, right? So, one could say, well, of course, that guy looks like he can kick your ass. That's not the legal standard. But then there are other biases and prejudices that petitioner would face, right? Depending on where he is. So there's also that. And maybe even though the world is changing, hopefully it continues to change for the positive, you don't want to air any kind of dirty laundry in court. In some places, you don't want to air the fact that you have a same-sex lifestyle. Because whatever. That's up to the petitioner, just like a petitioner in a hetero relationship doesn't want to air his or her laundry about what goes on in his or her house anyway. So, I feel like maybe everyone already knew that, and I wish I could have that all back, but just in case.
Thank you. Does anyone else have any questions? I can't believe there aren't more questions after such a wonderful program today. Anyone else have any questions? Please put them in the chat if you do. One thing I do want to mention is that in terms of MVLS, just as an FYI, if a person comes to us, a potential client comes to us and is seeking a protective order, we would not accept that client. Our program does not have the capacity to accept those types of cases. However, if there is a client who comes to us who is seeking custody, and somewhere along the line during that custody case, there becomes a protective order, or there is a protective order prior, then of course, that would be incorporated into the custody case, and we would take that case.
I have one of those right now with you.
You do?
Yeah.
Yeah. And there are a lot of other cases that, you know, under our program that we do take, and some that we have to sort of, I'd like to take all cases, believe me. You know, there are different parameters for every case, and certainly if you have any questions about those as you move along the program itself, please let me know, and we can always clarify those for you.
I put something in the chat. I don't know what kind of questions people have that they're holding back on, but if anyone out there is, you know, building a practice, so, you know, you're somewhat new, and Abdel has a question. You know, I added some input about what people generally charge. A caution on that, if you're going to do a flat fee, is that you might be waiting all day. You're probably waiting at least for the entirety of either the morning or the afternoon docket, because if it's not a consent, the judge's district court usually pass it. Different courts handle it differently. Sometimes circuit courts will put all the DVs at 8:30, and I don't know if you're first or sixth, but if you're going to do flat fees, you should know that your hourly rate might not be great. I would talk to your client, I would explain your flat fee, and therefore while you're waiting, you're going to pull out a different file, you're going to work on it, but you're available for that person as soon as they have something they want to say. But and then for the question about language line interpreters, Sarah knows more than I do. There's definitely Madovi, but Sarah, can you talk about that for victim impact statements and help with filing petitions?
Yes, language line has interpreters for lots of different languages, but whether you have access to it or not depends on who's doing the victim impact statement. So the state's attorney will absolutely give the client or the victim access to language line. The DV agencies all have it. As to individual attorneys, I don't know what that cost structure would be, but there.
How does that work, Sarah, when it comes to scheduling a TPO and an FPO if an interpreter is needed?
So there is the same language form that you would fill out, or request for interpreter that you'd fill out with a protective order that you would for any other case. I don't know if all courts do, but I do believe some courts have clerks or individuals that their entire job is to arrange for interpreters. There are for petitions, when you're filling out petitions, you can go to the clerk's office and they'll assign somebody to write out the petition for the person that does not speak English, and they just have to sign it saying it was written by that person. I would assume the same would be true for victim impact statements. I don't know if you can use the court's language line unless you're using it to file, though.
And when as a practice pointer, just like in any case, if you have an interpreter, it's going to take longer. If you're charging by the hour, you know, it's going to take longer. If both parties in a domestic violence case need an interpreter, it's been my experience that they each have their own, which is usually what happens. I had an unfortunate case where both of them spoke Chinese. I believe it was Mandarin. I know the Chinese itself is not a language. In any event, it came down to the interpretation of one phrase in one sentence as to whether or not it was a threat, and the interpreters disagreed. That was fantastic. But it was Judge Pamela Brown. She decided to, err on the side of protection, which, okay. But I just said, Your Honor, I'm supposed to advocate here. I don't speak Mandarin. So, so sometimes you get that situation. Yeah, just a little vignette.
With MVLS clients, I want you all to know that if you are need an interpreter, we have a free access to the language line, and certainly we will provide you with the appropriate information that you need, the contact information for you to be able to utilize that. It is very easy to use for any of you who have used Language Line. It is a simple process and works very well. The other thing about, we also have a free service for interpreting documents for your MVLS clients. It is called AYUDA, AYUDA. They primarily take cases and will interpret documents in Montgomery County and Prince George's County. However, if we make a push for another county, because we are the ones through, you would notify us of the need for a document needing to be translated, and we would then be the go-between with AYUDA to have that approved. And we can certainly make the recommendation that there is another county in need, and oftentimes they will be amenable to dealing with a client outside of Montgomery and or document outside of Montgomery and Prince George's County. So keep that in mind. I did put something out on the listserv about that recently. So if you find that need, let us know. The other thing that I have found is on our listserv, there are a number of people on the listserv who speak or are bilingual and speak other languages. In fact, I found out yesterday that Curtis Cooper, one of our speaks Russian, one of our yes, one of our adjudicator attorneys. And I thought to myself, well,
He's on this.
he's on our, yeah. And so there are a number of us, not us, I don't speak anything but English, and sometimes I have trouble with that. But just in general, there are people on the listserv that do speak other languages. One thing, this is a little off this topic, but one thing that when it comes to interpreters, we try not to, at MVLS, with our MVLS clients, we try to encourage our attorneys to utilize the language line rather than put the burden on the client to find someone to interpret. Now, if the client says, oh, my brother is coming with me and he can help, that's one thing. But we try not to, as I said, place that burden on the client to come up with an interpreter. Just as an FYI, they have enough problems on their mind that they don't need to be, saddled with having to find someone like that. So we encourage the language line in those circumstances. Any questions?
Sarah, did you see Curtis's comment about?
Yeah. Yes, I'm reading it now.
Okay. Curtis, I could say generally, well, not generally, also in the family law cases, we really encourage that. I tell everyone in every consult, because that way I can say it's true, that I tell everyone they should get a therapist because this is the hardest thing you're going to go through. And that's before I know whether or not there's any domestic violence in it, because I want to not want to take any stigma away. I want to give them permission to do it. But you are right. There are very always going to be deep issues. And it's, we really want them to evolve and grow psychologically and emotionally during the course of the family law case so that they can be more objectively reasonable rather than subjectively reasonable because the judge didn't go through their experience. So we love to work with therapists, but sometimes they won't sign the release and they want that safe space. Okay. Is there anything else you want to add to that, Sarah? I can certainly talk more about
I know if you're going to work with a domestic violence agency that works with your client, you need a very specific release. Domestic violence agencies will only, well, their grants limit what and how their releases need to look, in addition to what the law says a release needs to look like. So it needs to be a very specific release. It needs to have a specific expiration date. and it can only be about, you can only discuss what's in that release. I like to use therapists to see what grounding techniques work for my clients, what topics they know are going to trigger their client that I need to be extra cautious about or take more time with. There are lots of other issues that domestic violence victims could be experiencing, though, and I'm not sure if this is what your question is going to, but they could be dealing with financial issues, with the ability for housing. They could have issues with finding employment. That's when the domestic violence agency partnership comes in really handy, because they have advocates that's what they're supposed to do. They're supposed to help them work through their job search problems. They're supposed to help make sure that their pantry needs are met and their food needs are met, that they help them figure out a way to make sure that daycare is taken care of. So they connect with other resources, so that you don't have to try and balance that while trying to figure out their family law case. So I don't know if that actually answers your question or not. But I think partnering with the local DV agency on any cases that involve domestic violence would be very helpful, because they can take care of everything outside of the legal issues so that you don't have to.
And again, if you have an MVLS client, you can always reach out to our or I can on your behalf, either way, to our Human Trafficking Prevention Project manager, who is Heather Hyman, who can lead you to other resources and maybe guide you into some other area that could help you with some of these issues.
Yeah, but I mean, one of the reasons a lot of people stay in their domestic violence situation is because they are afraid they won't have anywhere to go and they won't have housing.
Right, that's a huge.
That can be addressed in the protective order, eventually in the family law case, but it can also be addressed through your partnership with the local domestic violence agency, who will either have resources for where housing could be found or potentially have spots themselves.
Any other questions? Any thoughts? Sarah, did you want to just recap
Sure.
in the summary some thoughts?
Sure. Domestic violence is more prevalent in our society than most people think, so don't minimize your client's perspective. I don't think anyone on here would. But things that might seem minor to us may not be to them, especially considering all of their history. Not all bad behavior is abuse. You can be in an unhealthy relationship and it not be abuse. Your clients might have very specific ideas of what they want, and that is, you will not be easily able to convince them that that is not something they're going to get, but you do have to continually remind them of realistic expectations. Again, memory is a problem in trauma cases, and they are going to, potentially more than my other family law cases, seek guidance from a lot more people. Their pastor, their therapist, their friend, their mother. They're going to then try and like choose which answer they like best. So you're going to have to continually redirect and try and find realistic solutions. Best interest is still what matters most in family law cases. The courts will consider domestic violence, both towards both child abuse towards the children and what they have witnessed. Keep safety in mind at all times. And again, their clients, regardless of abuse or not, aren't always the best at boundaries. So make sure that yours are strong and that you're enforcing them. And if for whatever reason you ever do break a boundary, make sure it's clear that it is like a one-time exception. So if you give your clients realistic expectations from the outset, you need to make sure that you're following them as well, so that they know what they can expect. Breakdown of attorney-client relationship is more likely to occur in cases where your client has been a victim of trauma than in others. If they don't know what to expect and they feel like they're you're putting them back into that situation where they never know what's going to happen. So give them realistic expectations.
Remember, they've been traumatized and they're looking for help, and we have been blessed with the education and therefore the ability to help a lot, but not solve everything. And they absolutely want you to do that, and they want you to make it completely right. And you can only do what the law does, and you can only ask for court orders. So that's what we mean by realistic expectations. And unfortunately, as time goes on, the court kind of expects them to evolve and to get over some, because especially if there's children, if not, whatever, right? Kind of give them the property and see you later. But because it's very important for the children that their father or mother, the abuser, not be vilified forever, because that affects the children's view of themselves. But we get a lot of unrealistic expectations from our clients, and they're very, as Cooper said, deep issues for them to work. Sorry, Curtis, very deep issues for them to work through. So sometimes I'll think okay, fine, we got that settled. This is not an alimony case, or we got this settled. It's safe for the children to be unsupervised, albeit a short time. And then 2 weeks later, the victim client is banging the table about, my kids are not safe because my friend had a situation. I saw something on TV. Expect that. You have to maintain the boundaries, not just set them. I hope that helps.
Yeah, I think many of our clients some of our clients from time to time, look at us and say, people are going to fix their lives, and we're not there to do that. Their lives go much deeper, and we don't live with them, and we don't have that kind of control and the ability to go to that realm of their expectation. But certainly to be clear about what we are able to do for them, and involve them in their own, I guess, rehabilitation somehow, by suggesting that they seek certain other options such as therapy, etc. We're not therapists, and I think sometimes we may be seen as that sometimes by our clients. Or at least it's expected of us to do more than what we are really able or professionally allowed to do. If there are no more questions, I want to thank Thomas and Sarah for this wonderful presentation. It was much needed. I do want to mention to all participants on the call that if you haven't had a chance recently to take a look at the MVLS website under Volunteer Resources Family Law, there are a number of over the last 2 years, we have really improved upon the number of resources available to you that should help you through your practice on a various number of topics. And I suggest you take a look at that. On the client side, under additional resources, you may find some fact sheets and some information you can actually share with your client, and you can print them off and use them and give them to your client as you need them. There is also on the website a representation agreement that is in both Spanish and English. So if you ever have the need to use that, please feel free to do so. So take a look at things on the website. I think you'll see that it's been beefed up quite a bit over the last couple of years, and there's a lot on there that you can utilize as you move through your practice and through your client representations. So I thank you all for coming. And again, Thomas and Sarah, hopefully we'll see you on the last and final
Sure.
representation in a couple of months. And
Ooh, on that point, you people out there who I can't see you, tell Nancy what you want to know about, so we're not like
true.
trying to guess. 'Cause I don't even know if this is what you wanted to know about, but yeah. And Nancy, you did a lot of work, so I know that everyone also thanks you.
Thank you so much, Thomas. I really appreciate that. All right, everyone, try to stay warm. I know I have, Sarah said she has 2 heaters in her office. I have 2 in mine. It's about 1 degree out there now. So stay warm, take care of yourselves, and have a great rest of your day and week.
Bye, everyone.
Bye.